days away. From sunrise till dawn I'll be here waiting. From sunrise till dawn I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn I'll be here waiting. From sunrise till dawn I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Today is Judge O'Donnell. Who's another good judge. So I'm going to be here watching. Let's get this party started.
Must prove you guilty beyond a reasonable doubt at a trial.
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to count one?
Yes. Cool.
Oh, yes,
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
yes,
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
yes,
All right, now, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination, in this case, is a felony of the third degree, and the penalties for a felony for this offense, there's a mandatory 60-day prison sentence up to 5 years in prison. Do you understand that?
yes,
There's also a mandatory fine of at least $1,540 up to $10,500. Do you understand that?
yes,
All right. In addition to the prison sentence, I could place you on community control for up to 5 years. Do you understand that?
yes,
There's also a mandatory driver's license suspension of between 3 years up to your lifetime. Do you understand that?
yes.
Any other penalties that I have to hit beyond that for
Just
this?
the mandatory drug and alcohol counseling.
As part of your sentence, and as would be part of your community control, or if you were in prison, you would have to undergo mandatory drug and alcohol treatment. Do you understand that?
Yes,
All right. If a prison sentence is imposed in this case, when that sentence is completed, then you might be on post-release control for up to 2 years under the parole authority. Do you understand that?
yes,
If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
yes,
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that? And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months for the time left under post-release control. Do you understand that?
yes,
Do you understand if a prison sentence is imposed beyond those 60 days, that you are eligible for judicial release?
yes,
And like I told you earlier, that I could, after that initial 60-day sentence, I could put you on community control for up to 5 years. But if you violate any conditions, I could send you to prison for the balance of that 5 years. Do you understand that?
yes,
The balance of there's a 5-year potential prison sentence, so I could sentence you to 5 years. Do you understand that?
yes.
All right. Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
I'm just very
No.
confused.
Just answer his question.
What do you want to say?
I'm a little confused about the jail time and everything.
All right, Pat, why don't you take her out, just talk to her and clear up any confusion, okay? Voluntarily will accept her plea of guilty and find her guilty of count 1 OVI of felony 3. Refer this for a pre-sentence report and a psychological evaluation. Sentencing will be July 2 at 1:30, and the bond is continued. Anything else, Ms. Wood?
No, I thought Maria gave us a different date yesterday. Did that change?
She did? I don't know.
Oh,
What did she
I
give
got
you?
July 2nd at 1:30.
Oh, okay.
Okay, anything else, Mr. Quinn?
No, Your Honor.
All right, we're adjourned.
Thank you, Your Honor.
Being trafficking in a fentanyl-related compound, a felony of the 5th degree. Count 2 being aggravated trafficking in drugs, a felony of the 3rd degree. Count 3 being trafficking in a fentanyl-related compound, a felony of the 5th degree. Count 4 being possession of a fentanyl-related compound, a felony of the 3rd degree with an attached forfeiture specification. And count 5 being possession of cocaine, a felony of the 5th degree. The defendant in the Menor Municipal Court was given a bond of $10,000 cash surety or 10%. The state is recommending that that bond be continued today. Thank you.
Mr. O'Connor?
Thank you, Your Honor. Your Honor, in regards to bond, Mr. Polinsky would be respectfully requesting consideration for an own reconnaissance bond. He recognizes for any future failure it appears that there would be other charges filed in regards to the matter. The last time, my understanding in talking with him, the last time he was given a chance on an own reconnaissance bond, he did get involved in treatment and did appear for any past hearings in regards to that matter. But he recognizes that the pressure would be on him. He wants to be able to get engaged in treatment and address his addiction issue. But because of that, we'd be asking for this opportunity. He has my contact information and he has provided me with his contact information. He'd be at 5500 Moreland Avenue in Menor, Ohio. But we would just ask consideration for an own reconnaissance bond.
All right, is he waiving reading of the indictment, any defects in time or service?
He is, Your Honor.
All right, not guilty, plea will be entered, the bond will be continued at 10,000 cash or surety or 10%.
All right.
point in time, the defendant was in Lake County knowingly receiving or retaining property that he knew or had reasonable cause to know was stolen, that being the Ford Explorer belonging to Nicholas Northup. And the conduct in receiving stolen property continued as that vehicle drove to the Pine Ridge Apartments as the aggravated robbery was committed, but then the conduct in the receiving stolen property continued to be committed until that vehicle exited Lake County. And while the time overlapped, the victims are different. The victim in count 3 is male victim NN, and the victim in count 1 is female victim BB, and the criminal objectives are different. The criminal objective in the aggravated robbery is to attempt to steal from victim BB a different vehicle than the vehicle that is property at issue in count 3. So the victims are different, the criminal objective is different, and the timing is different. Additionally, it is the state's position that by statute, the firearm specifications for counts 1 and count 2 must be imposed consecutively. The exception in revised code section 2929.14 B1G requires the court to impose 2 separate prison sentences for the 3-year firearm specifications. The Supreme Court has noted that this revised code section fails to provide an exception to its application when the underlying offenses have been merged, and that is from State v. Baller. And the reason for this is to acknowledge the hefty penalty of committing certain violent crimes with a firearm. Based on the plain reading of 2929.14 B1G, the Supreme Court concluded that offenders are required to receive separate prison terms for convictions when there are multiple firearm specifications. So because the firearm specifications in counts 1 and 2 must be consecutive by statute, and the firearm specification in count 3 should also be consecutive because it represents a separate after transaction than the conduct in count 1, it is the state's position that each firearm specification must be served consecutively for 7 years on the firearm specifications, and the state is asking for an additional 5 consecutive years on count 1, aggravated robbery, not including the Reagan-Tokes tail, for a total of 12 years. Thank you.
Okay, I've reviewed the pre-sentence report. The victim impact statement. I've also reviewed a letter from the defendant, from Ms. Brown, and from another individual in support of Mr. Hagwood. And I have considered all the provisions in 292911, 292912, and 292913. I note Mr. Fatika's objection to the consecutive nature of the firearm specifications in counts 1 and the count 2, which the underlying offense merged with 1. But I think it's clear under the statute and then by the decision of Baller that those 2 specs, even though 2 was merged with 1, must be consecutive, as well as the RSP in count 3. So I don't know what was, I sat here and listened to the evidence and determined that Mr. Hagwood was guilty of these offenses beyond a reasonable doubt, and it wasn't even a close call. I know that there was an argument and a remaining denial that his phone was present, but he was present, but the evidence was in my mind overwhelming that you committed these offenses on the date listed in the indictment. So, beyond what was stated in the victim impact statement, for somebody who had not ever been involved this, meaning the victim in this case, in anything remotely approaching this, it terrified her and continues to terrify her beyond belief over a year later because of what you and Bradley did. And I don't know why you did it. I mean, your mother wrote me a very nice letter on your behalf, spoke very well of you here, and you would have been a lot further ahead to follow her example in life instead of doing what you did. I can't for the life of me understand all this nonsense that you were engaged in that had a tremendous amount of harm on the people impacted by your actions. On count one, the felony one, I'm going to sentence you to a definite minimum term of 4 years up to an indefinite maximum term of 6 years in prison. Whether you serve any time beyond that definite minimum is based upon the criteria and your activity in the institution as determined by the adult parole authority. They could extend it to that 6 years. That would be subject to an objection by you, and you could at some point have a hearing on that, but that's based on their criteria. On the firearm specification of count one, I'm going to impose a mandatory 3 years. On the firearm specification that was in the count two, the attempted grand theft, a mandatory term of 3 years. Those two terms, those two firearm specifications will be consecutive to one another by statute and pursuant to Bowler, and statutorily consecutive to and served prior to your sentence on the underlying offense of 4 to 6 years. On count three, I'm going to sentence you to a term of, on the underlying offense of 18 months. That will be concurrent to your sentence on count one. The firearm specification by statute is 1 year is mandatory and will be served prior to the underlying offense. Anything more with regard to the sentencing? That aspect of it?
Your Honor, is the firearm specification in count three to be served consecutive to?
Yes.
Or the firearm specifications in counts one and two?
Yes.
Thank you.
When you are released, you will be on post-release control for 5 years under the parole authority. They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months of the time left under post-release control. You have the right to appeal your conviction and sentence, the 11th District Court of Appeals. You have a right to have a lawyer appointed to represent you if you cannot afford one. You have a right to have a transcript of all the hearings that have taken place in this case. If you can't afford the lawyer or the transcripts, they'll be given to you at no cost. You have a right to have a timely notice of appeal filed in this case on your behalf. I will appoint separate appellate counsel. So Mr. Fatigue, I would ask you to file a motion to withdraw, and we'll get somebody appointed. Is there anything else, Ms. Gold?
Jail time credit, Your Honor.
115 days, correct, I assume?
Yes, Your Honor.
Okay, credit for 115 days. Anything else, Mr. Fatica?
Your Honor, just going over the math, the aggregate sentence here then is 11 to 13 years?
Correct.
Thank you. Nothing further.
All right, we're adjourned.
All rise.
11.
Yes. They don't.
For 8 weeks.
No, I'm talking about
I'm
how many days in jail you do on this fire.
Oh, I'm sorry. 13.
I don't
13.
recall it taking just 1 second here.
It was 13 or 19. It was 13.
I think it's 16 actually. Let's see. It's 13 now.
Okay. All right, I'm going to continue you right now for community control. 13 days, credit for 13. Complete. Premier follow-up. And all the other terms that you were doing. And then when you complete Premier, then we'll just terminate your community control at that point, once you complete it though. And you can take off the scram now, that was part of your bond on this thing, okay? All right, so just follow up with the doc and finish up and you're done.
Just a question, I'm kind of off topic slightly. Is there any way that I can get some sort of protection order, no contact order or something from Christine?
I'll talk to him about that, Your Honor.
Okay, sorry.
Yeah, there is a way, but Mr. Deeb knows all that stuff. Okay? Did you changed the locks, right?
I did.
Okay. Where's she at the last 13 days? You have any idea?
She's living with somebody named John, somewhere in Perry or Madison. That's the best I can tell you right now.
All right, well, good for you. All right.
Better.
Your Honor, screams to be removed forthwith?
Yeah, because it was the bond condition, so the bond, there's no bond, so yeah, you can take the scram. Okay?
Thank you, Judge.
Thank you.
All right, good luck.
Thank you.
Defendant wishes to withdraw her previous entered plea of not guilty and enter a plea of guilty to an amended count 1, felony 3 attempted felonious assault in violation of 2923.02A, which is the offer in this case. In the sentence, recommended sentence, just a pre-sentence report at this time.
Okay, Mr. Fatika.
Good afternoon, Your Honor. I've discussed this matter with Ms. Jackson. I believe a knowing, voluntary, and intelligent guilty plea will be forthcoming in terms outlined by Mr. Downey.
Okay. Ms. Jackson, how old are you?
31.
How far did you go through school?
I graduated.
Are you a United States citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yeah, just roughly talk about it. He's asking you got a clear head. Just tell him that's what you're taking at jail. Okay.
Oh, and the meds that I'm taking at the jail.
What are you taking, do you know?
Clozapine, benzophine, Boost Bar, and one for my heart. I don't know, metformin tart for my heart, and then, let's say,
Did you take any of those medications today?
Yes. In the morning.
Do you understand what's going on here so far?
Yes.
All right, so it's been told to me you're gonna plead guilty to the attempted felonious assault of felony 3. Is that your understanding?
Yes.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm gonna ask you questions. If you don't understand the question, stop me. If you wanna talk to Mr. Fatika some more, stop me and I'll let you talk to him. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members of the jury must agree to a guilty verdict before I can find you guilty. Do you understand that right?
Yeah.
Do you understand that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yeah.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
All right, if you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of the transcripts, they'd be given to you free of charge. Do you understand that?
Yes.
If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control.
Yes.
The charge of attempted felonious assault is a felony of the 3rd degree, carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
Do you understand that your guilty plea, your felony conviction may prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, that you might have to serve, or you will have to serve a period of post-release control for at least 1 year, up to 3 years under the parole authority?
Yes.
You will have conditions placed on you. If you violate the conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison term for the violation would be either 12 months or whatever time is left on post-release control, whichever is more. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Fatika before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Mr. Downing, if the case went to trial, what would the evidence show?
Thank you, Your Honor. At trial, the evidence would show that on August 15th, 2024, Painesville police were dispatched to 63 South State Street, Apartment 6, in the city of Painesville, Lake County, Ohio, in report of an argument. When they arrived, they spoke with John Duncan, who was the owner of the apartment, and stated that the defendant was at the apartment with him, and they got into an altercation. He claimed that the defendant tried to swing a razor blade at him. He was not seriously injured. Officers went into the apartment and found the defendant in the bathroom. They handcuffed her, read her Miranda rights, and found on a kitchen table nearby a rusty box cutter style razor that was near her proximity that matched the description given by Mr. Duncan.
Mr. Fatika, anything to add to those facts?
No, thank you, Your Honor.
Ms. Jackson, did you hear what Mr. Downing said, that the facts would show if the case went to a trial?
Mm-hmm. Yes.
Are those facts true?
Yes.
What is your plea to attempted felonious assault, a felony 3?
Guilty.
Mr. Fatika?
Okay, this is the original of that. It's just wrote in here, you're taking at the jail, remember we talked about that?
We okay to sign, Your Honor?
Yep.
Okay, sign here, please.
Okay, Ms. Jackson, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept the written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Mr. Fatika advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, involuntary. I will accept her plea of guilty and find her guilty of attempted felonious assault of felony 3. I'll refer this for a pre-sentence report and a victim impact statement. Sentencing is September 10, 3/15, and the bond is revoked. Anything else, Mr. Downey?
No, Your Honor.
Mr. Fatika?
No, thank you, Your Honor.
All right.
All right.
Seated. Downey?
Thank you, Your Honor. We are present this afternoon in the matter of State of Ohio versus Gregory Johnson. This is case number 25 CR 758. Present in open court this afternoon is the defendant with his attorney, Jim Matthews. We were last heard on July 9th. At that time, the defendant pled guilty to amended count 1, felony 4, failure to comply, and count 2, felony 3, failure to comply. This court ordered a pre-sentence report and set sentencing for today. The state has had an opportunity to review the pre-sentence report prior to coming on the record and is prepared to proceed with sentencing at this time.
Mr. Matthews?
Thank you, Your Honor. Mr. Johnson is requesting to be placed on community control. He does, in his pre-sentence report, express remorse for having behaved the way that he did with his driving. He appreciates the fact that it did create a risk, and he has indicated that he has had an ongoing issue with alcohol, even though I do not have any reason to believe these offenses were alcohol related, but that has been an issue that has been plaguing him for a number of years, and he is asking that the court consider placing him on community control despite his record, which he of course acknowledges is less than stellar, but he does feel that if he were given an opportunity on community control that he could complete it, and that would be of tremendous assistance for him going forward. Thank you.
Mr. Johnson, what do you want to tell me?
I take responsibility for everything I did in this case, and I apologize to anybody I put in harm. It wasn't my intentions to. If I could take it all back, I would. This is not what I want for my life. I apologize to the court, my family. It's embarrassing, and I'm just really sorry.
Officer stops you on Dickerson, 4 houses down from where you were going, time and time again. Once he gets out of his car, you take off, going upwards of 80 miles an hour down side streets. Dickerson on Bay Ridge on Willowick Drive, past the middle school and elementary school. Blow through a red light at East 305th. Go to East 300th, go 80 miles an hour down that busy street, residential street. Turn on to Forest Grove. another residential street into Wickliffe, down Grand, another residential street through the red light at Lloyd, into Euclid. Go through a red light at 260th, another busy street, before they terminate. Officer says you were going well over 9 miles an hour down all those side streets. April 25th. Not too long after that, they figure out where you live, who you are and where you live. Contact your mother. Six days later, you're back, headed to that same house on Dickerson. They see your car. School's in session, school guard at 315th and Royal View. You stop in the middle of the intersection. Court guard says something to you, and your response to him is, "Go fuck yourself." Get stopped in that area. Cop gets out of his car. When he gets out of his car, you take off again, 70 miles an hour. And a 20 down Royal View, busy street, busy residential street. So they know your car from going to that house on Dickerson. They try to stop you twice in 6 days, and you take off, same activity each time. 08, you got an attempted failure to comply in Cuyahoga County. 7 months in prison. You got a misdemeanor drug conviction in Willoughby in 09. Domestic violence in Cleveland in 09. Failure to comply with the order signaled a police officer in 11 in Cleveland. 1 year prison sentence. Possession of drugs in Euclid in 13. Possession of cocaine in Lake County in 14. Put on probation, violate probation, go to prison. Trafficking in cocaine in 14 in Lake County. Prison sentence along with the previous case. 16, trafficking in felony in Cuyahoga. Concurrent sentence to the Lake County case. 19, attempted possession of cocaine. Lake County. In front of me, I send you to prison. 19, failure to comply with the order, signal of a police officer, misdemeanor in Willoughby, Muni. Now we got 2 more failure to comply. This isn't a mistake, this is what you do. Why you do it is up, I don't know, you do it because you don't want to get caught, but you do it, that's what you do. And I told these 2 lawyers in Chambers that this is worse than 100 miles an hour down the freeway, because you're going up and down side streets to people and cars all over the place. And you don't care. You're just going because you want to get away. When's the last time you had a valid license?
2019.
Okay, so why are you driving?
No. I can't say it, Your Honor.
Anything else you want to say?
I truly apologize. Like, I promise you, if I could take it all back, I would.
Well, you can.
I know.
I mean, part of accepting responsibility is not doing what you have been doing all these years. That's being responsible. This ain't being responsible. I mean, just because you plead guilty, that doesn't equate to taking responsibility. Mr. Downey?
Thank you, Your Honor. In addition to what the court has pointed out, just want to note that the defendant's license is suspended or in failure to reinstate status in 8 separate instances. He does have multiple traffic offenses, and from the state's perspective, what makes this more serious, in addition to the area was also the time of day, location of the school nearby, and the fact that he does have the prior convictions dating back to 2008 for failure to comply. So this is 17 years of this type of specific criminal behavior. And for those reasons, the state is asking for prison in this case, which is by law mandatory consecutive, and also asking for the court to impose lifetime driver's license suspension, which would be mandatory because he has a prior conviction in 2011.
Okay, I've reviewed the pre-sentence report. Listen to Mr. Johnson, listen to counsel. Considered all the provisions in 29, 29, 11, 12, and 13. And based on your record, specifically the multiple failure to comply convictions, I find you're not amenable to community control. On count 1, I'm going to sentence you to 12 months in prison. On count 2, 18 months in prison. And by statute, those are consecutive to one another with credit for 79 days. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which, the greater of 12 months, or the time left under post-release control. On that post-release control, you will be on it for 1 year, mandatory, up to 3 years. All the other terms of the post-release control are the same as what I told you. There's a lifetime license suspension by statute, and the costs are assessed. Anything else, Mr. Downey?
No, Your Honor.
Mr. Matthews?
Thank you. Thank you.
Knopf. Thank you, Your Honor. We are here on the matter of the State of Ohio versus Brandon Kokorin, case number 25 CR 000232. The defendant is present in open court with their attorney, John Patika. We are set today for a hearing on defense's motion for intervention in lieu of conviction. A pre-sentence report and an intervention assessment have been completed and submitted to the court. The defendant has 27 days of jail time credit.
Mr. Fatika.
Good afternoon, Your Honor. I've had an opportunity to review the intervention and lieu report in the PSR, and I'm ready to go forward.
All right, I'll grant the motion for intervention. How old are you?
I am 32.
How far did you go through school?
I got to the 11th grade. I did not get my GED.
Are you a U.S. citizen?
Yes, I
Are
am.
you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor.
You ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the information that was filed?
Yes, I did.
Have any questions about it?
No, I don't have any questions.
Do you understand you have the right to have your case presented to the grand jury for them to decide whether or not to indict?
Yes.
Did you discuss that right with your attorney?
Yes, I did.
Are you going to waive that right?
Yes, I am.
Sign.
Who's got the original plea form?
I have one.
Can I sign?
Yeah, yeah.
For the record, I've witnessed the defense and defense counsel sign the waiver of indictment. Now signing it myself. And would you like a copy of that?
Yeah. All right, I'll accept the waiver of indictment. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk some more to Mr. Fatika, let me know and I'll give you more time. You understand that?
Yes, I do, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, I am.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes, I am.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes, I am.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, I am.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, I do not.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
You understand by pleading guilty to these felonies that upon sentencing, you're giving up whatever freedom, your freedom for whatever period of time I sentence you to prison, to jail, or to community control.
Yes, Your Honor.
All right, aggravated possession of drugs is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're giving up those items listed. Do you understand that?
Yes, Your Honor.
Do you understand that if you are convicted of this offense, that it may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
Do you understand that a conviction on this offense would prevent you from owning or possessing a firearm?
Yes, Your Honor.
If you are sentenced on this case, do you understand that as part of your sentence, if you're sentenced to prison, upon your release, you could be placed on community control for up to 2 years under the parole authority?
Yes, Your Honor.
If you were placed on post-release control and violate conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If the violation were a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Your Honor.
And if that were the case, the maximum prison sentence for that violation would be 12 months or the time left under post-release control, whichever is more. You understand that?
Yes, Your Honor.
You understand if a prison term were imposed, you would be eligible for judicial release.
Yes, Your Honor.
You could be placed on community control for up to 5 years, but if you violate any of the conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, Your Honor.
If you can get convicted in this case, did anybody promise you what I would sentence you to?
No, Your Honor.
You understand I would not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Fatika before pleading guilty today?
Yes, I have.
Has he discussed everything about your case and answered all of your questions?
Yes, he has.
Are you satisfied with the advice he has given you?
Yes, I am.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No, I do not, Your Honor.
Mr. Knopf, the case went to trial. What would the evidence show?
Thank you, Your Honor. Had the case proceeded to trial, the state would have shown that on or about the 23rd day of December 2024 in Lake County, Ohio, the defendant was knowingly in possession of methamphetamine. Specifically, Your Honor, the defendant was at a parking lot in Wickliffe when officers observed the defendant throw something away in the trash can. Officers then went to go search what was thrown in that trash can, and they found a pipe containing methamphetamine residue confirmed by the Lake County Crime Lab.
All right, Mr. Fatika, anything to add to those facts?
No, thank you, Your Honor.
Mr. Corcoran, did you hear what Mr. Knopf said, that the facts would show if the case went to a trial?
Yes, I did.
Are those facts true?
Yes.
All right, what is your plea to aggravated possession of drugs, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
This is the original. So you can see the judge didn't make any marks on it.
Your Honor, for the record, I have witnessed the defense and defense counsel sign the written plea of guilty. I'm not signing it myself.
Mr. Corcoran, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
And do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present with Mr. Fatika, advised of all of his rights in an knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, find it to be knowing, intelligent, and voluntary, will accept his plea of guilty to aggravated possession of drugs, a felony 5, and the forfeiture specification. I'll stay the criminal proceedings. Mr. Fatika, do you want to speak as to the plan?
Yes, Your Honor. I'd just like to highlight the fact that Mr. Corcoran has a valid driver's license. He is employed as a roofer, no prior felonies, was candid in the PSR as well as the intervention report, was cooperative. We'd ask the court to consider implementing the recommendations in the ILC evaluation.
All right, Mr. Corcoran, what do you want to tell me?
Obviously, I have a problem with drugs. I've been battling them for a long time, and I'm starting to think a lot more clear now and what I want to do with my life, and it's time for me to grow up, quit with this nonsense, and hopefully you give me a chance to prove to you that I can do good on the outside without being locked up in here. Other than that, really don't have too much else to say.
Where do you live?
In East Lake, off Roberts Road.
With who?
One of my best friends,
Who?
Richard Lancaster.
What does he do?
He owns a plumbing company, Richard's Plumbing.
Does he use drugs?
Never in his life.
Okay. So why were you doing all this nonsense?
Maybe it was just out of boredom, maybe, loneliness, you know. I can't tell you the exact reason why, and I'm not, you know. I was a drug addict for going on 13 years. I was doing Percocet for the longest time, and then I went to treatment in November for a month in 24, and I was clean, you know, leaving there. I was clean for a couple months, got caught up with this stuff, and kind of just went into like a little bit of a depression and decided to do meth, I guess. Been working on it a lot, just been thinking about it a lot, and I'm getting older, and I want to change my life around. I'm done with the whole drug scene. You know, I have a good support system around me. Everybody's rooting for me, and I'm my own worst enemy, I guess. But I am doing, you know, thinking a lot more clear. I want to do better. I am going to do better. I just want to have the chance to prove to everybody that I can.
What led you to go to New Day Recovery?
I was done waking up sick from doing fentanyl every morning. So
Okay.
I was done with that lifestyle, and I picked up a different one, so it doesn't.
Why did you do that?
I don't know. I let something just happen, I guess, and next thing you know, I went into a downward spiral of me dropping one thing and picking up another, and it's not a good thing that I did that. I think about it now. I wasn't thinking about it then.
Well, so you got out of there in December of 24.
December 3rd of 24.
So how soon did you start using meth?
About 3 weeks after.
Okay, what were the circumstances of that?
I don't understand what you mean by that.
Well, you went to this New Day for a month.
That was to help me get off pills, because the fentanyl it's hard to get off fentanyl. You go through that horrible sickness of, you know, I couldn't do that at home. Could not get sober at home. I tried 100 times, and I needed like real help treatment.
So by the end of your stay there, your mind, I assume, is clear.
Yes.
And for roughly 3 weeks, it's clear. So did you think it was better to live with your mind unclear?
No, I haven't picked up pills since then. I was a meth user prior to going to treatment, but not as much. You know, meth has never been my drug of choice. You know, pills were my drug of choice. I can't tell you the exact reason why I picked up meth. It was not a smart thing. It made me not think clear at all when I was doing it. It was just me being stupid over the winter. You know, I was bored over the winter, I wasn't working, happened to pick it up, and obviously me being an addict, I liked it, and that's what happened.
So when do you usually work?
I'm a seasonal worker. I work in the winter, just not as much. All summer I work 7 days a week. In between, I mean, this has been a long winter. I got back to work around April and worked 7 days a week since I came here. I mean, I don't take days off in the summer. And then in the winter time, it's kind of spotty. I do try to do shoveling and everything and snow plowing when it snows and it's not just, you know, -5 degrees outside, but.
What kind of roofing you do?
Residential.
How long do you think you can do that?
Going on 16 seasons now. I don't know how much longer I got in me, but.
Okay, why don't you do something different?
I try to. It's easy for me to go back to it because it's something that's it's normal for me to do. I don't have to think about it when I go to work. I go to work, I do it, I do what I have to do, and it's just easy for me because it's such a normal, routine for me almost. I've been trying to get out of it for a long time now, but I know my roommate, he wants me to work for his plumbing company. He's been wanting me to work for his plumbing company. I've lived with him on and off for the past 12 years now, and I've been talking to him a lot while I've been next door, and he says, why don't you just come work for the company and, get out of all that other
Do your
stuff.
coworkers at the roofing company, do they dabble in the drugs too?
No, they don't.
Because a lot of roofers do.
I know they do. The company I work for is actually a really good company. They don't know that I do anything. I mean, they do now that I'm in jail, so I probably don't have a job with them when I get out. I mean, maybe I still do. There's still a chance just because I am decided to stay sober now, but I am going to have to talk to the boss about.
I mean, you can't climb up and down roofs carrying shingles for a lot longer when you've been doing it for 16 years.
No, I understand that.
So you got to figure something else out.
Mm-hmm.
Getting up on a roof after taking meth isn't a great idea either.
No, it's not at all.
All right, I'm going to place you on a 4-year intervention plan. You can sit down. You're going to serve 72 days in the jail, with credit for 27. 67 in jail, credit for 27. The last 30 you're going to be in the jail treatment program, complete it and follow all recommendations. No drugs or alcohol with screens. At least 3 AA meetings a week, AA or NA, and sponsor. Full employment. And then pay the costs and supervision fees. Anything else, Ms. Warren?
Your Honor, I just wanted to be clear, you said 67 days jail,
Uh-huh.
and then if you wanted to consider decision point.
Okay. Complete the decision point program, which will start while you're in jail. You understand all the terms?
Yes, I do, Your Honor.
Okay, if you don't comply, the state will file a motion to terminate your intervention plan. If I terminate it, then you'll be convicted of this felony. You understand that?
Yes, I do, Your Honor.
And then all those penalties that go along with that come into play. The items subject to forfeiture are forfeited. Anything else, Mr. Knopf?
No, Your Honor.
Mr. Fatika?
No, thank you, Your Honor.
Okay, that's it.
All right, thank you, Your Honor.
Thank you, Your Honor. We're here on the State of Ohio versus Diane Broadwater Wargo cases 95 CR 342 and 94 CR 581. The defendant is present pro se, and we are here for a motion on the defendant's motion for expungement or sealing of a record of conviction in both of these cases.
Okay. Is your last name Bliss?
My maiden name was Bliss.
All right.
I was charged under Broadwater, but it was never my last name. My last name now is Wargo. I'm married.
Okay. All right. I'm just gonna make sure we get this right when we do this.
Right.
So tell me what you've been up to since way back when, 30 years
Oh,
ago.
yeah. 30 years ago, regrettably, I made some very unwise decisions and had to suffer some consequences because of them, but over the past 16 years, I have been sober. I've been working full-time in the recovery field. I went back to school. I went to school full-time. I worked full-time. I got my associates in applied science. I got my bachelor's in psychology. I still work in the recovery field. I had my supervisors put some recommendation letters in my file that I faxed out. I emailed them over. I wasn't sure if you got them or not.
Okay. All right. So what led to you making that change?
I became a person that I knew I wasn't. And it took me a long time to pull myself out of the gutter and make something of my life.
Okay.
But I am married. We own a home. You know, I work full time still. You know, I am I pay my taxes, you know, I'm an ordinary citizen like anybody else. And this is just a part of me cleaning up the wreckage that I made throughout my past.
Okay.
You know, I help people on a daily basis navigate through the same situation, you know, and I tell them that they can do it if they try. You know, they just have to apply themselves. And, you know, unfortunately, I had 2 children that would not heed my advice. And unfortunately, one of them is not living any longer. And, you know, that's something I have to live with.
It's always a trick to get, you can tell everybody what they need to know. The trick is to get them to, like you said, to apply it. So,
Right. Right.
all right, the state's position on this?
Thank you, Your Honor. The state does not oppose the motion on either case.
Okay, so I will grant your motion to seal the records from those 2 cases. You're gonna need to get your fingerprints taken. Okay, he'll tell you where to go. Bob will tell you where to go. Just bring them back to the office here after you get them taken. And then Ms. Gold will have the entries prepared, going to the appropriate agencies, and you'll get a copy of one also that seals those records. Okay?
Thank you, Your Honor.
Community control in the 24/11/45 case. Those same terms will be implemented in this case with the exception of the jail time, which I just indicated. So just to review, complete the jail treatment program, follow the recommendations. Then you're going to go to Lake House or Concord Pines, complete that program, follow the recommendations, reside in sober living for at least 6 months after you finish Lake or Concord. No drugs or alcohol with screens, 5 AA meetings a week with a sponsor, mental health evaluation, follow the recommendations. At the appropriate time, maintain full employment, get a valid driver's license, only 1 doctor, only 1 dentist, and only 1 pharmacy. Sign releases for probation, take your medication as prescribed, no contact with Paige McLeod. So it's the same exact thing of what you're already doing.
Okay.
I think there's 2 5s on that other case, right? Okay, so if you violate, you're facing 24, and I find you violated, and you're facing 24 months on the 1145 case, plus 18 months on this case in prison. You understand that?
Yes, Your Honor.
Okay, so you're like the cat on its 9th life here. All right, anything else, Ms. Linden?
Just in terms of the post-release control potential.
I don't think I have to tell them that until I send them to prison.
Okay.
Oh, you ain't sending me to prison.
Well,
not yet.
Believe it or not, I don't want to send you to prison.
Yes,
So
I don't want to go.
I want you to be a productive member of society. So, but that's your call. All right, that's it.
Thank you, Your Honor.
All right.
Thank you.
All right.
not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand that by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Yes.
Felonious assault is a felony of the second degree. It carries a maximum prison sentence of 8 years as a definite minimum sentence. Do you understand that?
Yes.
It also carries an indefinite maximum sentence, the maximum of which on that end would be 12 years. Do you understand that?
I thought it carried 2 to 8.
It carries 2, 3, 4, 5, 6, 7, or 8 as a definite minimum. Okay, if I sentence you to, for instance, if I sentence you to 2 years in prison, that's the definite minimum. There's an indefinite maximum, which is 1/2 of that amount. That would be up to 3 years. So the sentence would be, if I sentence you to 2 years, that would be the definite minimum, up to 3 years as an indefinite maximum. You understand that?
Yes.
Okay, so if I sentenced you to 8 years as a definite minimum, the indefinite maximum would be up to 12 years, 1/2
Yes,
of the 8. Do you understand that?
I understand.
Any question about that?
No.
Okay, now whether you serve any time between the definite minimum and the indefinite maximum would be up to the criteria of the Department of Corrections. They would make a judgment as to whether any time beyond the definite minimum would be warranted. And it's a rebuttable presumption that you should be allowed out after that first number. Do you understand that?
Yes.
Okay. Any questions about the penalty?
No.
And there is also a maximum fine in the amount of $15,000. Do you understand that?
Yes.
All right, are you presently on post-release control to the parole authority?
No.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes.
You understand that if a prison sentence is imposed in this case, then you will have to serve a period of post-release control of at least 18 months up to 3 years under the direction of the parole authority.
Yeah.
If you are, or the parole authority would place conditions on you. If you violated their conditions, they could send you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If the violation of post-release control were a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that occurred, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violated any conditions, I could send you to prison for the 8 to 12-year period. Do you understand that?
Yes, sir.
All right, has anybody promised you I would be lenient on you just because you're pleading guilty?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
All right, do you understand at the time of sentencing, I do not have to accept the recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Mr. Mulkey before pleading guilty today?
No.
You haven't had enough time?
No.
Okay. Well, if you haven't had enough time to contemplate this, then I'm not going to accept your guilty plea. So why don't you talk to Mr. Mulkey and I'll be back, okay?
Sign here, date there. That's kind of hard. Sign here. And then it's 12/20/24.
So next time, what I see?
I've witnessed the defendant and his attorney sign the written plea of guilty here in open court. I've signed it as well. May I approach?
Yes.
Once the probation does their pre-sentence interview, I will review those notes, that report.
All right, Mr. Jackson Davis, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes.
And do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Mr. Mulkey advised of all of his rights, made a knowing, intelligent, and voluntary waiver of those rights. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept his plea of guilty and find him guilty of count 1, felonious assault of felony 2. And refer this for a pre-sentence report and a victim impact statement. Sentencing will be February 5 at 1:45 p.m. Is there anything further, Ms. Aleshi?
Does bond remain revoked, Your Honor?
It remains revoked, yes.
Thank you, Your Honor.
Mr. Mulkey, anything else?
Nothing further, Your Honor. Thank you.
All right, we're adjourned.
I would love to see you.
No.
Do you still want to plead guilty to these charges?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
In count 1, aggravated trafficking of drugs is a felony 3. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Count 2, aggravated trafficking of drugs is also a felony 3 with a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Count 3, receiving stolen property is a felony of the 4th degree with a 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
What's the minimum on this? Is it 5 to 10?
5, Your Honor.
All right, so with regard to the fines on count 1 and count 2, they're mandatory, so it's at least 5,000 up to 10,000 on each one. Do you understand that?
Yes.
I assume a affidavit's going to be coming?
Yes, Your Honor.
All right. On counts 1 and count 2, there's a presumption that a prison sentence should be imposed. You have to overcome that presumption at the time of sentencing, or a prison sentence must be imposed. Do you understand that?
Yes.
If there are no forfeiture specs on these?
No, it's a voluntary forfeiture.
You also understand there's a voluntary forfeiture of all the contraband. You understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 90 months and a maximum fine of $25,000. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
You understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm.
Yes.
Do you understand if a prison sentence is imposed in this case, and you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 9 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison sentence is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 90 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand that I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Mr. Geigerich, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that the defendant came to the attention of and targeted by Lake County Narcotics in January of 2024. Defendants set a deal on January 31st, 2024, the confidential informant for $80 or for $100 in meth, $100 for methamphetamine. Deal occurred at 3536 Shepherd Road in Perry Township, Lake County, Ohio. Deal did in fact occur. The suspected narcotics were sent to the Lake County Crime Lab. They test positive for methamphetamine Schedule 2 at an amount of 3.42 grams. He was again targeted on February 7th, 2024. Again, $100 for methamphetamine. The deal did in fact occur at 3536 Shepherd Road in Perry Township, Lake County, Ohio. The suspected narcotics were sent to Lake County Crime Lab where they test positive for methamphetamine Schedule 2 an amount of 3.62 grams. After these two buys, a search warrant was executed at the Shepherd Road residence on February 9th, 2024. Lake County Narcotics recovered a Ruger .22 caliber long rifle pistol, a Ruger EC9 pistol, baggies containing suspected meth, 2 digital scales with residue, 9mm ammunition, prescription bottle with the defendant's name on the dining room table with a baggie with white powder, a silicone container with suspected meth, multiple silicone containers with methamphetamine, baggies with suspected meth, a digital scale with residue. I mentioned these items because they're all going to be forfeited. The defendant was interviewed. He indicated that bedroom 1 was his, the firearms were his, and he admitted that the EC9, the Ruger EC9 pistol was stolen, and he admitted the drugs were him.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. Gonzalez, did you hear what Mr. Geigerich said the facts would show if the case went to a trial? Are those facts true?
Yes.
What's your plea to count 1, aggravated trafficking in drugs, a felony 3?
Yes. Guilty.
What's your plea to count 2, aggravated trafficking in drugs, a felony 3?
Guilty.
What is your plea to count 3, receiving stolen property, a felony 4?
Guilty.
Mr. Watson? Bob, this is the 27th, at what time? Do you know?
No, let me check for that.
Oh, never mind, she's got it here.
I think it's at 8 o'clock, Your Honor.
8:15. Gonzalez, is this your signature on the written plea of guilty?
Yes.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. The defendant was present. Mr. Watson advised of all his rights. Knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge, consequences of his guilty plea, and the maximum penalty. Finds to be knowing, intelligent, and voluntary. Will accept his plea of guilty. Find him guilty of counts 1 and 2, which are both aggravated trafficking in drugs, both felonies of the 3rd degree, and count 3, receiving stolen property, a felony 4. I'm going to refer this for an updated pre-sentence report and victim impact statement. Sentencing will be March 27, 8/15, and the bond is continued. Anything else, Mr. Geigrich?
Nothing, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
All right, we'll adjourn.
Yep, and I'll send paperwork over there in a minute. Okay, that's fine. For the updated PSR. Okay. Please don't get that started. All right, thanks. Thank you, Nick, thank you.
You have a beautiful day and a more beautiful tomorrow. I was gonna say good luck, Mr. Gonzalez, but I would have meant you.
Have a good one, Nick.
Yesterday I mentioned that, well, you can show me here where the dash cam should be located because I have not seen it.
Page 6, under count 2, having a weapon while under disability. Yes. The court is Lake County Court of Common Pleas. Case number.
Right, yeah, you said that before.
Oh. I think that was.
Out loud to the court, say, Your Honor.
Your Honor.
Hold on, she's still going.
When she's done talking,
I think that, do you have anything? Oh, yes. Where is it? There was an additional instruction on standby counsel on page 2 that is in OJI.
All right, I'll look at that again.
Okay. The same language on the verdict forms, if you want me to talk about that now?
No, you already said
Oh.
on the forfeitures.
Forfeiture, yeah.
Yeah.
And then, I think that was it. Other than that, I think everything else is good.
All right, Mr. Jordan?
Yes, Your Honor, can you have the plaintiff to explain how count 2 would read at this time? First paragraph.
It's gonna be language that's similar to what's in the indictment.
previously convicted of, and then whatever that language, it's in the indictment that references the drugs. And then to wit, possession of cocaine. It's gonna reflect what's in the language in the indictment.
Would that, just to clarify, would that say with possession of cocaine?
To wit, possession of cocaine, yes.
Seriously, wait till you get this in front of me.
Anything else in the instructions? All right, we'll revise them and get them to you so we can talk about them at noon again.
I need a moment to figure out, excuse me, Your Honor, I need a moment to figure out the discovery issue.
What's the discovery issue?
She was in the process of locating files that were transferred to me that I mentioned yesterday that are not on. So if she could coordinate with, this is the same file, if she could coordinate where the dash cam are located on the drive that I received.
I tried searching the USB that was provided to the defendant through discovery back on March 6th by manipulating, looking at the drive here in court. I did not find the dash cam file on there. However, I didn't have a chance to go through every single file folder contained on that USB. However, prior to providing that USB to the defendant back on March 6th, our office did index the contents of that USB, and our index reflects that the completed dash cam was provided on there. The USB was not locked for read-only after it was provided, so all I can say is when it was indexed, it was on there. If Mr. Jordan had done something to it in the meantime, I don't know. If that is the case, maybe it was just an accident. But I can also say that it was previously provided to defense counsel in this case. She was instructed to also provide discovery to the defendant.
Right, so what does he not have that he says he doesn't have right now?
If I'm correct in understanding, it's the full dash cams of all of the officers.
Actually, it's any dash cam. I have no dash cam. And if you could just coordinate with your files, where would it be located? Because I did search for dash cam since I was advised by my attorney prior that there was dash cam. And I had not manipulated, only viewed the files, and like I then noticed, I received this file on a Thursday, viewed it over the weekend, and when I realized that it was missing some material, I set forth the same motions indicating so.
Do you guys have the index? Could you just email
The index is on the docket.
on the docket?
Yeah.
I did not preview the file prior to signing, so I cannot verify that what's on the docket is what was on the drive itself.
So we're talking about the, not items 3 through 7, exhibits 3 through 7, we're talking about the full three dash cams?
I believe so.
Okay, where are they?
We have them here in court on the state's drive that the defendant can use in trial if he wishes. We can separately provide those again on a USB to the defendant at this
Are you
time.
gonna use them today?
Yes, I would like to.
Okay, then why don't you let him use whatever you have?
We have no issue with that.
And then you can have somebody over there make, get to 3 on a new jump drive or whatever you have to do.
We will do that.
All right. Anything else before we start?
No, Your Honor.
Hold on, Bob. Come on back here.
Yes, sir.
Would it be under the image, the notice of discovery by state and request for reciprocal discovery?
Yes, it would have been in the filing on 3/6/25.
It's telling me no image available.
I'm looking at the image, so I don't know.
Did you log in at?
No.
Allison? You might have to log in to see images.
But yeah, it is in that notice of discovery and request for reciprocal discovery.
Can you just email it to me?
Yeah.
I honestly don't even know my password. Which computer? Over there.
What's your email?
afhibbard@gmail.com. Which computer? No, shit. Where is your physical flash drive?
It's there on the computer.
Which, on that computer?
Yes,
The one up there?
yes.
But I see two computers from here.
You see the one with the projector under it?
Oh, it's in that drive, okay, I see. Gotcha. That black box. Okay.
I just sent it.
Thank you.
Could you email it to me, please? Is this the file that we were just speaking about?
Email what?
Would this be the flash or dash cam?
No, I'm just asking her for a copy of the index,
Oh, okay.
so that we can see the index, you know?
Rachel just emailed IT to put it on another flash drive and have it brought over. But we have all of the dash cam available on USB too.
But I just need to know if there's a certain place within the videos that you want me to go to, Mr. Gordon. Is there?
I would
going to
actually
be?
have to preview them. I haven't had a chance to preview them
Okay.
in its entirety. Since I did it for me on a Thursday and here when trial started Monday.
Mhm.
And they were in the file at that time.
If you had an issue with it, why didn't you contact me Monday and say they were missing so I could then
I
give you
did, I
another
actually
copy?
placed a motion to compel discovery.
You filed that Tuesday morning when trial was starting, but
Actually, I filed that Sunday when trial started, well, the day before trial.
okay. Okay,
So, trial started Monday or Tuesday?
Tuesday.
And I was working that whole day Tuesday or Monday. And still trying to discover the discovery, so much files to look through.
So you gave them to him as what, both the redacted clips and the full dash cam?
If that's what's on the index, yes.
Mrs. Woods,
Mm-hmm.
did I hear you say in your jury instruction presentation that there was no cocaine in your inventory?
Just the word cocaine was missing in discussion about the forfeiture specifications, and it includes the word cocaine on the indictment, so we just asked that that be
Okay.
added to the forfeiture specification language.
Okay. Is there a way for me to get prints from that, or it's all,
What do you mean?
like if I wanted a print of this right here on the screen? And also, if I put something on the screen, how do I submit it as evidence?
Okay, so that depends on,
Complete dash.
if you're putting it on, you can only put it on the screen if you are using it
Right?
well, if it was, we'll talk about during the
It has to be
case.
relative to
With
what's
regard
going-
to your, yes, correct, with regard to your cross-examination, okay? And it would have to be admissible, but once you did that, so if you wanted to point to that, say the lab person is testifying and you want to point to that, okay? You would, that they're already probably going to have,
How do I put it on
displayed that,
to
but
evidence?
you say I would like to, well, if you're just showing, for the entire jury to see,
How do I submit it as evidence?
you would have to move to admit it.
Okay, but I mean physically, with mechanically. How does
So
that
if you're
submit?
like holding this and there's a witness on the stand,
Yes.
Yes.
I mean, right, so how do I, is there something I must do? How do I submit it electronically?
yes.
Do you know?
Like, technologically, do I know, or legally, do I know?
So Rachel,
Technologically,
once
not
this is up
really.
here, how do I submit something as evidence?
I can't understand what he's asking
Mechanically.
technologically.
What
Oh, like in the technical?
yeah,
So you would ask the appropriate questions to the witness, and then from either that computer or I can put it in mine, we would show it to the witness on all of the screens
Yeah,
before.
can I do that?
Will you take that off?
Can you take it off the board, please?
Sure. Did it time out?
You turned off the screen.
How do I get in? I really can't. Space that out.
Approximately how long was Miss Thomas performing fellatio on the defendant before he blew the smoke in her face?
I would say maybe 6 to 9 minutes.
What was Miss Thomas's reaction when the defendant did that?
She didn't do nothing. She didn't say nothing. She didn't get mad. Nothing.
Did that bother you?
Yes,
Why?
because we don't smoke crack. We don't indulge in that type of stuff, and you just let this man blow crack smoke in your face for any amount of money. Like, that's not okay. It's already bad enough that we were out here selling our body, and you just sold your body to a, I'm sorry to say this, but a crackhead.
And you had testified the defendant said he was hitting a 40, is that correct?
Yes,
What is a 40?
I guess a 40 piece of crack. Like, he was literally stuffing that glass thing with that dope. He was grabbing from on top of that metal thing. And I watched him put crack on the pillow, crack on his kneecaps, crack on the stem.
Approximately how many times did you see the defendant smoke from the pipe?
He did it about a good 7, 8 times before he got mad.
Let's talk about when the defendant got mad. You previously testified that you had put an address into your phone, is that correct?
Yes.
Okay. What address did you put into your phone?
4200 Stelzer Road, Columbus, Ohio.
So is your address to get home.
Yes.
How did the defendant react to this?
I guess once he heard that, he rose up and said, "Y'all bitches trying to rob me." And he snatched my phone, snatched his phone, threw my phone behind the bed. When I tried to grab it, he like mushed me away from where my phone was, and that's when he grabbed his, thing,
What thing?
his gun,
Where did he grab the firearm from?
from behind that bed where he threw my phone.
What was the defendant doing with the firearm?
He just waved it and was like, "Y'all bitches trying to rob me," and just kept waving the gun. And I'm like, "Sir, can I get my phone so I can go home? I'm not from here." And Destiny, I don't know how she ended up getting out his door, because the way the door was, it was like booby trapped or something. And she got out the door, and he ended up closing the door after she left. And I was still in the apartment, and I kept asking him, "Can I just get my phone so I can leave?" And every time I tried to go to the door, he just got angrier and angrier.
When you say the door was booby trapped, what do you mean by that?
It had locks, like more than one lock on the door.
Was it difficult to exit or open the door?
Yes.
What were you doing once Miss Thomas was able to get out of the apartment?
I stood at his living room window screaming.
What were you screaming?
Somebody help me get out of here. He won't let me out of here.
After that point in time, or what was the defendant doing while you were screaming that?
Just walking around his house butt naked. Hi.
Did he still have the firearm?
Yes.
Did he still have the crack?
No, once he heard the police come, he was coming out the room, and when I heard the police, he was already at the door, and that's when I started assaulting him.
Let's talk about when the police arrived. Do you recall hearing the Willoughby Police Department knocking on the door?
Yes.
Would the defendant open the door?
Yeah, he opened it while they were screaming Willoughby police.
What happened once he opened the door?
I hit him in his head, the door got opened, and it looked like 10 officers, but it probably wasn't. It was probably like maybe 3 or 4. But he fought them for dear life for about, I would say, 3-4 minutes.
What were you doing during this 3 or 4 minutes?
The officer told me to stand at the door and not move, so that's what I did.
You previously testified that you hit the defendant as well?
Yes.
Why did you hit him?
He was stealing my phone and had me held hostage in his home.
Were you scared for your safety?
Of course I was.
When you say you testified the defendant was struggling with the police, is that an accurate way to state it?
It wasn't no struggle. He was fighting them.
Can you describe that for me?
Like, it looked like 10 officers to get that skinny man on the ground.
Approximately where in the apartment was this struggle occurring?
In the living room.
The cell phone you had on you that day, do you recall what type of cell phone it was?
An iPhone XR.
Do you recall what it looked like?
It had a glitter case, a clear glitter case, and it had like blue, purple, pink glitter. Could y'all close this window? It's cold.
What's that?
Could y'all close this window, please?
Hey, Bob, can you shut these windows?
Yeah.
Thank you. I'm freezing.
May I approach the witness, Your Honor?
Yeah.
I'm going to hand you some gloves, if you wouldn't mind putting them on prior to handling the evidence, as well as scissors. I'm handing you what's been previously marked as State's Exhibit 17. Can you please open that envelope and tell us if you recognize the contents inside?
My phone.
That's the phone you had on you the night of June 20th of 2024?
Yes.
Is that the same phone that the defendant took from you?
Yes.
When the defendant took your phone, what did you see him do with it?
He threw it behind his bed.
Your Honor, may I publish State's Exhibit 10C at this time?
Yeah, it's been admitted.
Thank you, Your Honor. while this is getting, oh, here it is. Up here on the screen, I'm gonna display what's been previously, admitted as State's Exhibit 10C. Is what's depicted in this photograph look familiar?
Yes, that's Mr. Jordan's apartment.
Is this similar to how it looked on the early morning hours of June 20th of 2024?
I mean, it's cleaned up very well, but yeah.
It looks a little different.
Yeah, it's just cleaner.
Is the bed and bed frame in approximately the same location?
Yes.
When you said the defendant threw the phone behind his bed, can you describe where in the photograph that would have been?
Where at the top where that bed is touching the wall, my phone was right there.
Directly underneath what appears to be a stereo player?
Yes.
Up on the shelf? Did you see what the defendant did with the firearm prior to police arrival?
No.
Ms. Lewis-Scannell, you were also arrested as a result of the incident on this night, is that correct?
Yes.
And you subsequently pled and were convicted of assault and engaging in prostitution in Willoughby Municipal Court, is that right?
Yes.
And did you receive any deal or benefit from the state of Ohio in exchange for your testimony here today?
No.
Do you see Mr. O'Shea Jordan here in court?
Yeah.
Can you please point to where he is seated and identify what he is wearing?
The brown sweater, glasses, bald head.
Your Honor, may the record reflect the witness has identified the defendant?
Yes.
Prior to this night, had you ever met the defendant before?
No.
No further questions.
All right, cross-examination.
Mrs. Gunwell, is it?
Gunnell.
Gunnell. Sorry, and thank you. I'm sorry. You stated that upon you entering the home of the defendant, that it looked like a death trap.
It
May
did.
I ask you, at that point when you felt like it looked like a death trap, well, first, can you describe what that looked like to you?
You had paint, extension cord, ladders, hammers. It didn't look like a home.
So did it look like a work zone or a death trap?
It looked like a trap house, if you ask me.
Okay, so it felt like a death trap to you is what I'm understanding.
Yeah.
I want to know, when you felt a death trap, why didn't you immediately turn
I
around?
wasn't leaving my friend in your house.
Okay. Before I ask any more questions, I would like for you to tell the court, true or false, if you were threatened to come here and testify today.
No.
Okay. So you mentioned that your friend and I were in the bedroom. Can you just elaborate on what that experience was from your perspective?
My friend was giving you oral in your house, and you were smoking crack, and you stole my phone.
Where was your friend located during this time?
In between your legs, you know where she was at.
Where were you located?
Sitting on your bed,
And where was I located?
laying down, up under your little homemade shed or whatever you want to call it.
So you're saying where all three were laying in the bed?
We weren't laying in nothing. You were laying in your bed. She was in between your legs, and I sat at the edge of your bed the whole time I was
You never
there.
laid down in the bed?
Me?
Yeah, had you ever?
No.
Okay. Do you recall a moment when money was unauthorized and cashed out via the defendant's phone onto either Destiny's phone and either your phone onto a third or fourth party?
You sent somebody in your phone $300 and said thanks for putting me in the hospital, and you said that we were trying to rob you. No one ever touched your phone.
How do you know that was sent?
You showed us. You
And
sat
what was
there.
the name of that?
I don't remember.
Okay.
You showed us your phone before you snatched my phone, sir, and you know this.
Thank you. Can you recall at what point that the chaos disturbance began?
We was there probably 45 minutes, if that. I don't remember. That was last year, but yeah, we was probably there. I would say we was there from the time we walked in the door till the time we left, maybe an hour, hour and a half, if that.
Would you be able to remember if it was close around the time when the defendant discovered money missing from his phone that you guys started to exit?
I didn't exit your home until the police told me to leave. So.
Oh, okay, so then would you say it was around that time when the defendant discovered money missing from his phone that Destiny exited?
I don't remember. I just know after you snatched my phone, we was out of your house. Maybe, I would say 15 minutes, if that, after that.
Let me ask you, do you remember a point in time when you and your companion, Destiny Thomas, began to exit in unison together?
What does that mean?
Meaning you both got up at the same time and began to leave the apartment?
We never left your apartment at the same
Do you remember
time.
a time similar to that where you both got up at the same time and began to leave?
We never left your home at the same time. Destiny left your house first, and you closed the door and kept me in your home.
Let's keep it in perspective. We're still in the bedroom. Do you remember a time when you both got out of the bed and began to leave the apartment or the bedroom in unison?
We all stood at your door and argued after you took my phone.
What happened during that argument?
Hold on. You can't, let her finish the answer before you ask another question.
All three of us stood at your door and argued, and I begged and pleaded for my phone for about a good 3 minutes before Destiny got out of your home.
Okay. During that argument, do you recall anyone pulling out a knife? If it was
A knife?
Yeah.
Nobody had a knife. You had a gun.
Do you recall anyone trying to stab the defendant in that entrance of the doorway, the bedroom?
Who tried to stab you?
I'm asking, do you recall?
No.
Okay. Let the record reflect that Destiny did have a knife in her pocket when she was arrested.
You cannot
That
make
don't have
statements.
nothing to do
Hold
with
on. I'm talking.
Sorry.
You cannot make statements. You can ask questions. The jury's instructed to disregard his last statement. Ask a question.
Okay. Did Destiny have a knife on her person that night?
I don't know. They had us all separated. The police did. You as well. You were the first one in the cop car.
Okay.
I know my friend had drugs on her. I don't know about a weapon, though.
Did you yourself have drugs on you?
No, I did not. Did I go to jail for drugs?
Hold on. Listen, you can't ask him questions either.
Sorry.
Okay?
Now, as your friend has left the apartment, where are you and I at that time when she...
In your living room, I stood by your window screaming, and you ran around your house butt naked.
While you were standing by the window screaming?
Yes.
Did you have an opportunity to notice any police outside the building?
No, I just heard them when they were at the door.
So, let me re-ask it. When you were standing at the window, running around the apartment screaming, back and forth from the window screaming, did you notice any police outside the building?
I heard them, but I did not physically see them until your door came open.
Okay. So now, when your friend, prior to the police arriving, your friend has already exited and made a phone call to police.
Right. She made the phone call to the police inside of your house.
I'm just laying the foundation. You're still in the apartment running from the window in proximity of the front door. Do you recall hearing your friend make a phone call to the 911
I
operator?
told her to call the police.
Okay. So, while she's making the phone call, do you recall her opening the door at one point while she's on the phone with the operator?
Yes.
And where you and I located, you and the defendant are located at that time?
She was at your door and I was like by your kitchen and your bedroom area and you were in your room.
So she was able to open the door after leaving the apartment, call 911, come back and open the door, peek in, and close the door back.
She never,
As you ran around the apartment.
I don't recall her opening your door again, but if she did do that, I don't remember that.
Can I have a brief moment to speak with my assistant?
Well, I'm going to go ahead and end this for today, ladies and gentlemen. I'm feeling a little bit under the weather today. We're trying to be here tomorrow. So you all, you have a wonderful evening. Ta-ta and ciao-ciao, and I will see you on the next one.
come down to it all, with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.